Hey, everybody. Great to see you all. Great that you're all back. And guess what? We have another spotlight coming your way, and it's perfect. It's SEC, and this is going to cover a lot in 20 minutes. So let me get through the introductions because I'm just so excited about this person that we're interviewing. Talk about living in the eye of a hurricane. Our next spotlight government official, Kristina Littman, does so 24/7, be it crypto, data breach, privacy. Talk about crossover. Whatever the tech, the chief of the SEC's Division of Enforcement's cyber unit is at the center. And the cyber unit is a national specialized unit that focuses on protecting investors and markets from cyber related misconduct, which has grown exponentially in terms of breadth and scope of their jurisdiction. And it's not easy these days to say anything that's remotely anti-crypto with all the hate, the vitriol, and the misinformation that can often be spread by crypto enthusiasts. But Kristy, she takes it all in stride. She still fights so that everyone has a voice. She enjoys a stellar reputation as a tough but fair law enforcement official and a regulator who fights to protect investors above all else. She ventures into worlds that most SEC enforcement lawyers do not even understand. She is Dana Scully meets Diana Prince. Thanks for being here, Kristy. Hey, and thanks for your service too. You deserve a big thank you. And welcome.
Thanks, John. A pleasure to be here. I always love speaking on a panel where you introduce me.
Thanks. Well, interviewing you and speaking with you is Luke Tenery, one of the veterans of the IR Forum, a partner with the global consulting firm StoneTurn, a veteran of the IR Forum, as I said. His bio will tell you that what makes Luke a cyber expert is not just his 20 years of experience helping mammoth organizations mitigate complex cybersecurity data privacy and protection risks, but you may miss the fact that Luke is also a certified CISO from Carnegie Mellon and a certified network penetration tester. And that enables him to manage the investigation of a data security incident and also fix it afterwards. And with not just with better tech, but better governance as well. And like a board member who can instantly step in and become CEO, Luke has become known to step in as an acting CISO amid an IR. And he's the quintessential expert that you want in the foxhole with you. So let's get to it. Welcome, Luke. Can't wait to listen to the next 20 minutes. Thank you both.
John, thanks so much. As we expected, and Kristy alluded to, I'm ready to go through a wall. But we are definitely excited here, and Kristy, for your visibility. One, we know how busy you've been of late. All sorts of, to use John's word, mammoth information and current events coming out of the SEC, particularly with cyber. Tell us sort of a little bit about the state of play, key issues, and your role. We're really eager to find out what sort of the hot button areas are from your vantage point.
Sure. So first, I have to give my disclaimer. The views I express are my own and do not necessarily reflect the views of the commission or my colleagues on the staff of the commission. But to get into it, as John alluded to, the cyber unit kind of wears a lot of hats. We have a lot of different responsibilities. Of course, digital assets and crypto assets are a big part of that, and we bring a lot of actions in that space. We're also responsible for cybersecurity, which will be the focus of our discussion today. But then we also have this kind of bucket of trading cases that we're responsible for as well. And so those are usually some sort of trading misconduct related to the use of technology. Like, we brought a case with false rumors in chat rooms where they were trading around those rumors, creating the rumors and then trading around them. If you have, fake tweets, fake Edgar posts or filings in order to try to move the price of a security, we'll be responsible for those cases as well. Dark web, things of that nature. But getting back to kind of this cybersecurity mandate, we have essentially two categories of cybersecurity responsibility. The first is at regulated entities. So those are your investment advisors, your broker dealers, and your Reg SCI entities. And our responsibility there is really kind of looking at their underlying programs, policies, and procedures and making sure that they're up to par. And then the second piece is the issuer aspect of our cybersecurity work. And so when we're looking at an issuer, we're usually looking at their disclosures. If they have an incident, we want to look at their disclosures and make sure that they're timely and accurate. We'll look back at their risk disclosures and make sure that their risk disclosures have been accurate over time. And then we may also look at internal controls depending on the nature of the incident. But what I'll say is, in all of these instances, right, issuers, regulated entities, it's a complex judgment for us. We recognize that in the face of a cybersecurity incident, the issuer or sometimes the registered entity is also the victim, and they're dealing with the aftermath of the incident. So, we are mindful of that and cognizant of kind of all of the obligations that you're dealing with in that respect. But, we have an obligation, and frankly, the issuer or the registrants also have an obligation to balance those considerations with responsibilities to investors.
That's well said. I find myself usually want to take notes to my own benefit, just given how much visibility you're providing. But I'm going to plow through this. I know we're only on a 25-minute segment here. You referenced already, Kristy, elements of kind of key concern, and you also alluded to the recently proposed measures. You may have actually alluded to them here just a little bit, but I was wondering if you could just sort of unpack those a little bit more in terms of the key measures, the proposals that have come out just in the last few months, and really what's sort of driving those, if you can say.
Sure. I think, look, cybersecurity is obviously an area of a priority area for the commission, both on the regulatory and the enforcement side. We brought a number of cases in the last year focused on this space, but and two rule proposals, right? There's the investment advisor and funds proposal, and then there's the issuer proposal. I think we want to talk today about the investment advisor and funds proposal. This is really, I want to say, in some respects, it's not all that different from the way we already think about these cases. I think the existing safeguards rule says that you need to have policies and procedures reasonably designed to, relating to the risks that your business presents. And this is no different. It has that same kind of tailored to your business operations, including its complexity and the attendant cybersecurity risks. But this kind of goes a little further, lays out some basic features, and is a little more prescriptive about what that means. Mm-hmm. So I'll kind of walk through some of those measures that are laid out in the new proposal. One, you've got periodic assessments of your cybersecurity risks. The other thing I'll say as I walk through these, in my experience, I think a lot of firms are doing this, or they are attempting to do it. Perhaps having a more prescriptive list like this helps them, go down the checklist and make sure that they're covering all of these. But it is, when I look at the investigations we conduct in this space, we're often looking to see whether they're doing these things, because these are really what a reasonably designed policy and procedure would look like, which is the existing requirement. So periodic assessments of cybersecurity risks. And then you want to look at what information systems are being used and how a cybersecurity incident might impact them. So you should be looking at your service providers. Are your controls designed to minimize user-related risks or unauthorized access? You want to look at the standards for behavior for individuals and making sure that they're using systems that they're authorized to access, the acceptable use policies. Identifying and authenticating users. I think we're going to talk a little bit later about a series of cases we brought that touched on some policies and procedures around that. Password controls, how are they distributed? How are they replaced? How are they revoked? Again, things you should already have in your policies and procedures, but if this rule is adopted, you'll absolutely need to. Access restrictions. So if you have information systems that have PII, for example, you need to have policies and procedures in place restricting access to those for people who actually need access to them to perform their jobs. Securing remote technology is a part of the proposal. I think everyone recognizes the importance of this in light of everyone's telework status for the last 2 years. So you've got to make sure that you have information protection measures in place and threat and vulnerability management. And then also incident response and recovery. So you have to have a plan for continuity of operations, protecting systems and the information that resides on those systems. And there are obligations to report to the commission in the event of an incident. And then there are also some kind of like annual reporting and books and records requirements, but I think those are kind of the highlights of the new proposal.
That's a great overview, Kristy. And I think if I were in the audience and how I've kind of worked with compliance and risk folks, I know that, one, they want to know what the duties are generally and are interested in a checklist, but they're learning increasingly that these are sort of living and breathing things. So these things don't it's not sort of a once a year sort of check-in. And what I mean by that is the organizations, whether it's in preparedness or in a response situation, this kind of key element of visibility in terms of, at least at a high level, if they're in compliance, they want to know that things are functioning well. Some of these dynamics prescriptively that you described, they have some essential visibility into. And switching gears a little bit to sort of the enforcement side, and I mentioned visibility in not too distant past. I think with your kind of name and statements on it, the First American enforcement dynamic comes to mind. And I know that at least one of the key issues, and I don't want to speak on anyone's behalf, but part of that from my vantage point, because I often do wear the CISO hat, it sounded like there may have been certain areas of visibility to that, perhaps even on the security side of the house, but that visibility link may not have been there with senior management. Some of the other kind of maybe more material duties that surface there were. I was wondering if you could just talk a little bit about, what just some of the dynamics of enforcement there, if there's anything notable that you think is worth offering a First American. I know you may have an element or two to say on Pearson's as well, but if you could just kind of speak to that, because I think the visibility component there may have saved a lot of heartache in that situation.
I think that's right, Luke. The underlying charge in First American was a disclosure control violation. And so the focus was less on the kind of like substance of that particular disclosure and more around the procedures that led to it. So in that case, there was a violation related to a vulnerability that a cybersecurity reporter had uncovered and was reporting on. And in response to that reporting, the company issued a press statement and they furnished a Form 8K in response. Now, of course, the senior executives at the company were responsible for those public statements. And what our order alleges is that at the time that they had those responsibilities and made those public statements, they weren't apprised of certain information that was relevant to their assessment of the company's disclosure response to that vulnerability. And specifically the magnitude of the resulting risk. So senior executives there were not informed at the time that they made those disclosures that the company's information security personnel had actually identified the vulnerability several months earlier and had failed to remediate it in accordance with the company's policies. And so, according to our order, that failure was a result of a failure to maintain disclosure controls and procedures designed to ensure that all of that available relevant information concerning the vulnerability was analyzed for disclosure in the public reports that the company filed with the commission. So it's really kind of a lesson on being prepared for responding to an incident and making sure that you have procedures in place and that you're following them.
Yeah, I think part of the challenge is there, people aren't in a firefight all day, every day. And then, you realize the need for some of those procedures, when that fire unfortunately eventually comes. I think one of the drivers there too, that we wanted to get to, because maybe there's confusion or people are actively learning and reassessing this. And I'll get to the kind of the point here in a second, but of late, I worked a pretty massive incident, and there's sort of, to your point around procedures, part of the shift, Kristy, I think organizations are facing where, like back in the day, very early stages of data breach response, there was sort of we assess, what records were affected that help counsel drive the decision on, the state to state and other duties, that spectrum, or there's really a panoply now of sort of regulatory concern. But I would say the most notable shift now for organizations in sort of their notification and response, or how they should prepare, is that a lot of these notifications now are almost real time. And, so they're not just having to wait until all the forensics are done, but there is sort of this visibility piece perhaps that need to be given to regulators that an incident is ongoing or being dealt with. But I think also they're grappling with, what hits the threshold, Kristy, what constitutes something hitting that material level that sort of trips the wires or what have you. Can you speak to just the materiality piece and the connection with the commission in that sense?
Sure. I think it's an issue everyone grapples with when they're dealing with an incident. Is this material? Do we need to disclose it? What I think I would tell you is, first of all, there's some really good guidance on this. There's a 2018 guidance that CorpFin put out on cybersecurity disclosures, and it's worth a read. It talks about materiality, but it talks about a lot of other governance issues as well. So if you haven't read it, it's worth the read. But what I would tell you is that I discourage companies from using a purely financial metric in assessing materiality. It can be tempting because you want a really definitive answer. And I think quantitative materiality is what you aim for to get that definitive answer. But the reality is that what a reasonable shareholder considers important might not take into account whatever financial metric you're using, the size of the business unit impacted, the revenue produced by that unit. I think there is a real tendency to drive towards one of those quantitative analyses, but there's real other qualitative impacts that you need to be considering. The nature and extent and the potential magnitude of the incident, particularly as it relates to an impact on the company's operations, or the importance of any compromised information. So it could be from a relatively small part of your business, but if it's sensitive information, that's likely to be qualitatively material to shareholders. And there's also a range of harm that can flow from an incident like that. You could have reputational harm. It could impact your financial performance in the future. It could impact your customer or vendor relationships. And then it could result in litigation or regulatory consequences. So there's kind of a range of qualitative factors you should be thinking about. That doesn't mean you don't also consider the quantitative factors, but I wouldn't limit your analysis of materiality to quantitative factors. And I think a good example is the Pearson matter that you alluded to earlier. In that matter, we found that the issuer's disclosures were not fulsome or accurate. And the underlying information that was breached there was information about students' data. So it was information about children. And I think it was particularly, material for that reason. In that case, Pearson had experienced an incident and they didn't disclose the breach to investors at the time that they learned of the incident. Later, they were contacted by the media and they issued a reactive media statement that they had prepared in advance at the time that they learned of the incident. But when at the time that they issued that reactive media statement, it understated the nature and the scope of the incident and it overstated the company's data protections. So that resulted in a 17A2 and 3 charge for misleading statements and omissions.
Thank you for that. I think, one of the kind of misestimates that we see in some of our work, because really, Kristy, we're seeing it on both ends of the spectrum, perhaps a middle market, smaller company in response, or at least by market cap, it is material. It's immediately apparent in their ability to deliver operationally, which is directly tied to revenue. And then there's even larger organizations now that I think grapple with this because one, maybe the world and the street are just so numb to the incidents and not immediately seeing the material impact. I can also say, from our vantage point, a lot of there's a deferred impact in the sense of what that could mean from a revenues or how that impacts earnings. Ultimately, it doesn't always happen right away. Sometimes it is a direct operational impact. and you see the dollars lost from a ransomware perspective, or it's further on downstream from a relationship impact. And I think it's notable too for the audience. It's not just what the Ponymon Institute or someone else anymore says, like what the cost of a breached record is. Obviously, customers are affected, but now we're talking shareholders. I mean, my retirement's affected, probably anyone else that owns an index fund as well. So those are all sort of key points in that sense. Switching a little bit to the response side of things, Kristy, I think obviously we know that you can't speak to a lot on or much, if anything, on the investigation side, but you did sort of allude to earlier controls. I think controls tie to specifics around the types of cyber attacks or response scenarios that the participants might find themselves in. I say that because you mentioned, I think, broker dealers, investment advisors. There seem to be some very specific specificity to those controls for some of those parties. And I was wondering if you could just unpack those in terms of, I don't know if there's a top 5, top 10, beyond just the procedural things that you mentioned that you would, have the audience be aware of today.
Well, I think actually the new rule proposal is a really good touchstone for investment advisors and funds with respect to kind of their obligations under the safeguards rule. And we, with respect to Reg SID, that does actually have some relatively prescriptive measures in it that are worth looking at to make sure that your programs are in line and complying with Reg SID. But Reg SP, the current requirement that we're enforcing is that, policies and procedures reasonably designed to protect customer information. And I'll give you an example of an area where some firms have fallen short and we've brought some enforcement actions. Last summer, we had what I call a mini sweep, where we had 3 different actions that sanctioned 8 firms for failures in their cybersecurity policies and procedures. And in those cases, in each case, it resulted in an email account takeover that ended up exposing PII of thousands of customers and clients at each firm. It was KMS Financial, Cambridge, and Cetera. So you can find all of those on our website. But we charged safeguards rule violations, and in one instance, a compliance rule violation. They were all registered as broker dealers, investment advisors, or dual registrants. And they all had written policies and procedures that included enhanced security measures for systems that contain PII. In this case, it was multi-factor authentication. That was the enhanced security measure. But they also all failed to implement that measure across all the parts of their business where that PII was accessible. In some instances, those failures persisted in the face of known attacks and infiltrations. And so, we brought an action because I think, and what I said at the time, and it's so certainly true, is it's not enough to have a written policy in place if you're not actually implementing it and pushing it out across the impacted users of your systems that contain PII. In that case, one other thing I'd like to be clear about, it was multi-factor authentication. In that case, that was what each of the firms had written in their policies was the appropriate enhanced security measure. That doesn't mean that it's always going to be MFA, right? There could be some new measures next week that supplant MFA, but whatever your business decides is the right security measure to enhance, you've got to make sure that you're implementing it broadly and that you're protecting PII across the board.
Yeah, what we're seeing on that, on the technical side, I feel like I need to chime in. From our perspective, they're oftentimes protecting clients are their core corporate systems with MFA, but they oftentimes neglect or choose not to or lose sight of some of the more consumer or customer-facing apps due to usability, user experience. But those are the actual people that are driving revenue, and ultimately, I think speaks to how that can turn into a material issue. I think we've only got about
in these cases, to be clear, it wasn't the kind of investor-facing application. It was like independent contractors who the company had contracted with and given access to the PII systems. which is, I think, part of the takeaway. Make sure if you've got independent contractors or other vendors that you're granting access to your systems, that you've got those same controls in place.
Thanks for that clarification, Kristy. I think I'm about to get the hook from Bruce, but I was wondering if there were any kind of closing points on kind of what's the next or key concern on enforcement from your vantage point, or any closing thoughts. You're welcome to share that with us.
Sure, and I'll be quick so that we don't get yanked off stage. I think, look, the new rule proposals, both I think are really indicative of the focus on this area. Issuer disclosure is paramount. You've got to protect your internal financial controls as well. So make sure that those are up to snuff. For registrants, look at your safeguards, look at your identity theft programs, make sure that they're compliant. And then I think one other point is if you do have an incident and you prepare a reactive media statement, which is something I see pretty commonly, and you don't issue it, but you're going to issue it later if you get a reach out from press, look back at that statement, make sure it's still accurate. A lot of times you learn more about an incident in the intervening period. You've got to update those disclosures and make sure that what you're giving to investors is accurate and represents the full spectrum of what you know.
Yeah, they're changing real time in incidents, and maintain that visibility, I think, is key in keeping up to date. All right, thank you. Really appreciate Kristy. Bruce?
Thank you, Luke. Kristy, thanks so much for joining us. The SEC and your role in particular at the SEC is so key now in these incidents, and it's so important to hear from you and find out what you and your group and your agency are doing. Thank you so much.